Our neighborhood, Willowbrook Estates, was the kind of place where everyone seemed to know everyone else's business, and where rules were strictly enforced by the ever-watchful HOA. The president of the HOA was a woman named Karen Pierce, who had a reputation for wielding her little power with an iron fist and zero tolerance for any perceived infractions. So when I found three brightly colored notices taped to my front door one chilly morning, I knew immediately it was Karen's doing. The first notice complained about the excessive clutter in my front yard, some potted plants and a couple of chairs that I had temporarily placed outside during a patio renovation. The second accused me of unauthorized modifications to the exterior of my home, referring to a new mailbox I had installed, and the third threatened fines if I didn't remove the unauthorized items within 48 hours. I sighed and pulled the notices down. Karen's relentless policing of the community's minor details was nothing new. But what she didn't know was that I was far from an ordinary homeowner. I'm Margaret Maggie Hall, and I work as the clerk of the Supreme Court of the United States. It's a position few outside the legal world fully understand, but it means I'm deeply familiar with laws, procedures, and the due process that even HOAs must follow. After a few days, I wrote a calm, professional letter to the HOA board addressing the notices. I pointed out that none of the violations actually breached any official covenants or bylaws. The potted plants were movable and perfectly acceptable under the guidelines, and the mailbox was an approved design. I reminded them that proper notice and hearings were required before levying fines. Still, Karen seemed determined to escalate the situation. The following week, I found more notices taped to my door, this time threatening legal action if I didn't comply. I knew it was time to show her that while she had authority over a small community, I had years of experience in the highest courts of the land. I requested a formal hearing before the HOA board. I appeared in person, carrying copies of the neighborhood covenants, relevant state laws, and procedural guidelines for HOA actions. I calmly explained to the board and to Karen that their notices were not just unfounded, but procedurally flawed. Then I dropped a little bombshell. I am the clerk of the Supreme Court of the United States. I understand the importance of rules, procedures, and fairness better than most. I expect the same respect and due process be extended to me as a resident. Karen's face turned a pale shade of red. The board was visibly taken aback. Suddenly, Karen was no longer the unchallenged enforcer, but a member of a committee facing someone with undeniable authority in the legal system. After that meeting, the HOA ceased all unjustified notices and fines. Karen sent me a quiet apology and even helped arrange for a neighborhood cleanup event, which I gladly supported. The incident became a lesson for Willowbrook Estates. While HOAs have authority, that authority must be exercised fairly and lawfully, and sometimes the person they try to intimidate is the one who knows the law best.